Part 2. Rights of data subjects and others. 5. For the purposes of this part. A. In the case of an individual who 1. Is a minor, the rights conferred by this part may be exercised by a parent or legal guardian of the minor, or by the minor in any case where the law recognizes the capacity of the minor to act in the matter to which the personal data relates, or 2. By reason of any mental impairment is unable to act, the rights conferred by this part may be exercised by the person's nearest relative. Within the meaning of Section 3.3 of the Mental Health Act, so, however, that a. Such a relative need not be ordinarily resident in Jamaica, and b. The court may, where it considers it appropriate in the circumstances, on an application made to it by a relative of the data subject, determine the nearest relative suitable to exercise the rights notwithstanding the order of precedence referred to in Section 3.3 of the Mental Health Act. b. In the case of any other individual, the rights conferred by this part may be exercised by 1. The legal personal representative of that individual, or 2. Another individual to whom the first mentioned individual delegates in writing, in such form and manner as may be prescribed. The exercise of the rights. 6. 1. The rights conferred by this section are subject to the exemptions set out in Part 5, to the extent indicated in that part, and a. Data controller shall determine in each case whether compliance with a request lawfully made under this section can be achieved without compromising the confidentiality of the exempt data, by severing the exempt data from any information required to be disclosed under this section. 2. Subject to the provisions of this section and Sections 7 and 8, an individual is entitled, upon making a written request to a data controller, a. To be informed by the data controller, free of charge, whether personal data of which that individual is the data subject are being processed by or on behalf of that data controller. b. If personal data are being processed as described in paragraph a, to be given by the data controller, free of charge, a description of 1. The personal data of which that individual is the data subject. 2. The purposes for which the personal data are being, or are to be, processed, and 3. The recipients or classes of recipients to whom they are, or may be, disclosed. c. Upon payment of the prescribed fee, 1. To have communicated to that individual in an intelligible form, a. The information constituting any personal data of which the individual is the data subject, and b. Any information available to the data controller as to the source of those personal data, or 2. Where technically feasible, to have transmitted a. To another data controller specified in the request, and b. In a structured, commonly used and machine-readable format, the personal data of that data subject, which the data subject has provided to the first mentioned data controller, and d. Where the processing, by automatic means, of personal data of which that individual is the data subject, 1. Is for the purpose of evaluating matters relating to that individual, such as, for example, the individual's performance at work, creditworthiness, reliability or conduct, and 2. Has constituted or is likely to constitute the sole basis for any decision significantly affecting the individual, to be informed by the data controller, upon payment of the prescribed fee, of the logic involved in that decision-taking. 3. An individual making a request under this section may, in such cases as may be prescribed, specify that his request is limited to personal data of any prescribed description. 4. Subject to Section 8.1. A data controller shall comply with a request under this section promptly and, in any event, before the end of the period of 30 days, or such longer maximum period as may be prescribed, beginning on the day on which the data controller has both the request and, where applicable, the payment referred to in subsection 2.5, for the purposes of a. Subsection 2c, and d. different amounts may be prescribed for different circumstances. b. Subsection 4. Different periods may be prescribed for different circumstances. 6. If the Commissioner is satisfied, on the written application of any individual, who has made a request under this section, that a. the data controller in question has, in contravention of this section, failed to comply with the request, the Commissioner may order the data controller to comply with the request, or b. the data controller has complied with the provisions of this section in dealing with the request. The Commissioner may dismiss the application. 7. For the purposes of determining any question whether an applicant under subsection 6 is entitled to information under this section, including any question whether any relevant personal data are exempt from this section by virtue of Part 5, the Commissioner, a. may require the information constituting any personal data processed by or on behalf of the data controller in question, and any information as to the logic for any decision as mentioned in subsection 2d, to be made available for the Commissioner's inspection, and b. shall not, pending the determination of the question in the applicant's favor, require the information to be disclosed to the applicant or the applicant's representatives. 8. The Commissioner may appoint a duly qualified mediator to consider any matter to be determined or inspected by the Commissioner under subsection 6 or 7, and make such recommendations to the Commissioner as the mediator thinks fit for the settlement of the matter, and the Commissioner may act on those recommendations. 7.1. The obligation imposed by Section 6.2c1 shall be complied with by supplying the data subject with a copy of the information in permanent form unless a. the supply of such a copy is not possible or would involve disproportionate effort, or b. the data subject agrees otherwise, and where any of the information referred to in Section 6.2c1 is expressed in terms which are not intelligible without explanation, the copy shall be accompanied by an explanation of those terms. 2. For the purposes of Section 6.2c intelligible form, in the case of a person with a disability, as defined by the Disabilities Act, means a form that would render the information readily accessible by the person, having regard to the special needs of the person, and regulations may prescribe circumstances in which the requirements of subsection 2c shall be taken to have been met. 3. The information to be supplied pursuant to a request under Section 6 shall be supplied by reference to the personal data in question at the time when the request is received, except that it may take account of any amendment or deletion made between that time and the time when the information is supplied, being an amendment or deletion that would have been made regardless of the receipt of the request. 8.1. Where a data controller a. reasonably requires further information in order to satisfy himself as to the identity of an individual who makes a request under Section 6 and to locate the information which that individual seeks, and b. has informed the individual of that requirement, the data controller is not obliged to comply with the request unless the further information is supplied to the data controller. 2. Where a data controller cannot comply with a request under Section 6 without disclosing information relating to another individual who can be identified from that information, the data controller is not obliged to comply with the request unless a. the other individual consents to the disclosure of the information, or b. it is reasonable in all the circumstances to comply with the request without the consent of the other individual, and the data controller has notified that other individual of the data controller's intention to comply with the request. 3. In subsection 2, the reference to information relating to another individual includes a reference to information identifying that individual as the source of the information sought by the request, and that subsection shall not be construed as excusing a data controller from communicating only so much of the information sought by the request as can be communicated without disclosing the identity of the other individual concerned, whether by the omission of names or other identifying particulars or otherwise. 4. For the purposes of subsections 2 and 3, another individual can be identified from the information being disclosed if that other individual can be identified from that information alone or from that information and other information which, in the reasonable belief of the data controller, is likely to be in, or come into, the possession of the data subject making the request. 5. In determining for the purposes of subsection 2b, whether it is reasonable in all the circumstances to comply with the request without the consent of the other individual concerned, regard shall be had, in particular, to a. Any duty of confidentiality owed to the other individual. b. Any steps taken by the data controller with a view to seeking the consent of the other individual. c. Whether the other individual is capable of giving consent. And d. Any express refusal of consent by the other individual. 6. Where a data controller has previously complied with a request made under Section 6 by an individual, the data controller is not obliged to comply with a subsequent identical or similar request under that section by the individual unless a reasonable interval has elapsed between compliance with the previous request and the making of the subsequent request. 7. In determining for the purposes of subsection 6, whether requests under Section 6 are made at reasonable intervals, regard shall be had to the nature of the personal data, the purpose for which the personal data are processed and the frequency with which the personal data are altered. 8. Section 6(2)(d) shall not be regarded as requiring the provision of information as to the logic for any decision if, and to the extent that, the information constitutes a trade secret. 9. Where personal data requested under Section 6 a. is not in the custody or control of the data controller, the data controller shall in writing so inform the individual making the request, or b. are personal data which the data controller is entitled to refuse to disclose to the data subject by virtue of any provision of this Act, the data controller shall in writing inform the individual making the request that the disclosure is refused and identify the relevant provision relied on for the refusal, within 30 days after receiving the request. 9. 1. Any consent required to be given, by a data subject, to the processing of personal data. A. Means any informed, specific, unequivocal, pre-given, expression of will by which the data subject agrees to the processing of that data subject's personal data. B. Includes any such expression of consent given by 1. The legal personal representative of the data subject. 2. Any individual to whom the data subject delegates, in writing in such form and manner as may be prescribed, the right to give or withhold consent to processing. 3. In the case of a minor, subject to Section 5a, 1. A parent or legal guardian of the minor, or 4. In the case of an individual who by reason of any mental impairment is unable to act, the person entitled to act for that individual. Under Section 5a, 2, and c, may be withdrawn in the same manner in which it may be given under paragraph a. 2. For the purposes of subsection 1. a. Informed with reference to the giving of consent means that at the time in question the data subject is informed about how the personal data will be processed, including the purpose for which the data will be used and the class of persons to whom the personal data may be transferred, and b. Consent is not freely given if the data subject is required, as a condition for the provision of any goods or services to the data subject, to consent to the collection, use or disclosure of the data subject's personal data beyond what is reasonable for the provision of those goods or services. 10.1. A data controller shall not process personal data of a data subject for the purpose of direct marketing unless the data subject a. consents to the processing for that purpose, or b. is subject to subsection 4, a customer of the data controller. 2. A data controller shall not approach a data subject, whose consent is required in terms of subsection 1a, more than once in order to request that consent. 3. A request for consent in terms of subsection 1a shall be made in the prescribed form and manner. 4. A data controller may, pursuant to subsection 1b, only process the personal data of a data subject who is a customer of that data controller. A. If the data controller has obtained the contact details of the data subject in the context of the sale of any goods or services. B. For the purpose of direct marketing of the data controller's own similar goods or services, and C. If the data subject has been given a reasonable opportunity to object, free of charge and in a manner free of unnecessary formality, to such use of that data subject's personal data. 1. At the time the personal data was collected, and 2. On the occasion of each communication with the data subject for the purpose of direct marketing. If the data subject has not refused such use. 5. Any communication to a data subject for the purpose of direct marketing shall contain a. The details of the identity of the sender or the person on whose behalf the communication has been sent, and b. An address or other contact details to which the recipient may send a request that such communication cease. 6. In this act, direct marketing means to approach a data subject in person or by any means of communication, whether electronic or otherwise, for the direct or indirect purpose of a. Promoting or offering to supply, in the ordinary course of business, any goods or services, or b. Requesting a donation of any kind for any reason. 11.1. Subject to subsection 3. On any of the grounds set out in subsection 2, an individual is entitled at any time, by notice in writing to the data controller, to require the data controller a. Within a period which is reasonable in the circumstances, to cease, or b. Not to begin processing, or processing for a specified purpose or in a specified manner, any personal data in respect of which the individual is the data subject. 2. The grounds referred to in subsection 1 are that, for reasons which shall be specified in the notice under subsection 1. A. The processing of the personal data, or the processing of the personal data for that purpose or in that manner, is causing or is likely to cause substantial damage or substantial distress to the data subject or to another, and that the damage or distress caused or likely to be caused, as the case may be, is unwarranted. B. The personal data is incomplete, or irrelevant, having regard to the purpose of the processing. C. The processing of the personal data, or the processing of the personal data for that purpose or in that manner, is prohibited under any law, or d. The personal data has been retained by the data controller for longer than the period of time for which it may be retained by the data controller under any law. 3. Subsection 1 does not apply. A. In a case where any of the conditions set out in section 23(1) is met, or b. In such other cases as the Minister may specify by order in accordance with section 74(3)(b). 4. A data controller who receives a notice under subsection 1 shall, within 21 days after receiving the notice, give the individual who gave the notice a written statement. A. That the data controller has complied or intends to comply with the notice, or B. Of the data controller's reasons for regarding the notice as, to any extent, unjustified and the extent, if any, to which the data controller has complied or intends to comply with the notice. 5. If the Commissioner is satisfied, on the written application of any individual, who has given a notice under subsection 1, which appears to the Commissioner to be justified, or to be justified to any extent, that the data controller in question has failed to comply with the notice, the Commissioner may order the data controller to take such steps for complying with the notice, or complying with the notice to such extent, as the Commissioner thinks fit. 6. The failure by a data subject to exercise the rights conferred on that individual by subsection 1, or section 12(2) shall not be construed as affecting any other right conferred on the data subject by this part. 12(1). This section applies to a decision, other than an exempt decision, taken by or on behalf of a data controller and which significantly affects a data subject. 2. An individual is entitled at any time, by notice in writing to the data controller, to require the data controller to ensure that no decision to which this section applies is based solely on the processing, by automatic means, of personal data in respect of the data subject for the purpose of evaluating matters relating to the data subject, for example, the individual's performance at work, creditworthiness, reliability, or conduct. 3. In any case where a data controller who has not received a notice under subsection 2, in respect of an individual takes a decision to which this section applies. A. The data controller shall, as soon as is reasonably practicable, inform the individual that the decision was made on the basis described in subsection 2, and B. The individual is entitled to, within 30 days after receiving the information under paragraph A, by notice in writing, require the data controller to reconsider the decision or make a new decision otherwise than on that basis. 4. A data controller who receives a notice under subsection 3b shall, within 30 days after receiving the notice, give the individual in question a written statement specifying the steps that the data controller intends to take to comply with the notice. 5. If the Commissioner is satisfied on the application of a data subject that a data controller has failed to comply with a notice under subsection 2, or 3b, the Commissioner may order the data controller to reconsider the decision, or to take a new decision, that is, not based solely on such processing as is described in subsection 2. 6. An order under subsection 5 shall not affect the rights of any person other than the data subject and the data controller. 7. In this section exempt decision means any decision A, in respect of which the conditions set out in subsection 8 are met, or B, made in such other circumstances as may be prescribed. 8. The conditions are that A. The decision 1. Is authorized or required by or under any enactment, or 2. Is made in the course of steps taken A. For the purpose of considering whether to enter into a contract with the data subject or with a view to entering into such a contract, or B. In the course of performing a contract entered into with the data subject, and B. Either 1. The effect of the decision is to grant a request of the data subject, or 2. Steps have been taken to safeguard the legitimate interest of the data subject, for example, by allowing the data subject to make representations. 13.1. An individual may in writing to a data controller request that the data controller rectify any inaccuracy in any personal data A. in the possession or control of the data controller, and b. of which the individual is the data subject. 2. For the purposes of subsection 1. Inaccuracy includes any error or omission. Rectify means amend, block, erase or destroy, as may be required to correct the inaccuracy. 3. Where a data controller receives a request under subsection 1, the data controller shall, within 30 days after receiving the request, determine whether a rectification is required and a. If no rectification is required, include with the personal data concerned an annotation of the correction that was requested, and notify the individual making the request that no rectification was made, or b. If a rectification is required, make the rectification and give notice of the rectification to 1. the individual making the request, and 2. so far as is reasonably practicable, every person, or other entity, to whom the personal data was disclosed at any time during the period of 12 months immediately before the date of the request. 4. Upon receiving a notification under subsection 3b, the person, or other entity, to whom the personal data was disclosed during the period mentioned in that provision shall make a corresponding rectification of such of the personal data concerned as is in that person or entity's possession or control. 5. A data subject may appeal in writing to the Commissioner against any determination made by a data controller under subsection 3, and if the Commissioner is satisfied a. as to the actions taken by the data controller under this section, the Commissioner shall dismiss the appeal, or b. that the data controller erred in making a determination that no rectification is required, or erred in the type of rectification required to be effected, the Commissioner shall order such rectification of the personal data as the Commissioner considers appropriate, and the data controller shall comply with the order. 6. Where an appeal is made to the Commissioner under this section, the Commissioner may appoint a duly qualified mediator to inquire into the matter and make such recommendations to the Commissioner for the resolution of the matter as the mediator considers appropriate, and the Commissioner may act on those recommendations.